Hello, everyone. Welcome to Freedom of Information Law Workshop. My name is Colin. I'm Colin DeVries. I'm president of the Deadline Club, the New York City chapter of the Society of Professional Journalists. And since 1925, we have defended press freedoms and supported the journalism community in New York City. Please check us out at deadlineclub.org. on Twitter, Instagram, Facebook, LinkedIn, and YouTube. So thank you for joining tonight. Holding freedom of information events like this is a critical mission of SPJ, and we're grateful to be able to provide this service to you all. Now let me introduce our guest and our presenter for the evening, Matt Leish. He is a partner at Miller, Korzenik, Sommers, Rayman in New York. And a longtime media lawyer with more than 20 years of experience. He and I actually worked together at the New York Daily News while he was assistant general counsel at the Tribune Publishing Company. So Matt, take it away and tell us all about freedom of information.
All right, thanks, Colin, and hello, everybody. Thanks for joining us tonight. I'm happy to be here. So as Colin said, I'm going to give kind of an overview of some freedom of information issues. I'm going to talk about both the New York State Freedom of Information Law and the Federal Freedom of Information Act. I'll be happy to answer questions at the end if people have questions. Let me try to share my screen here and see if I can do this. Okay, so as Colin said, my name is Matthew Leish. I'm with Miller, Korzenik, Sommers, and Rayman. I spent a lot of years at the Daily News and then with Tribune Publishing. So I've worked with reporters doing both FOIA and FOIA work, including and also doing work like that for my current clients. So I thought I would start with just kind of an overview. As most of you know, New York has a statute called the Freedom of Information Law. The federal statute is the Freedom of Information Act. And starting with New York's Freedom of Information Law basically provides for access to records held by all state and local government agencies. And agencies are defined as any state or municipal department, board, bureau, division, commission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental function for the state or municipality thereof. So basically, any unit of state or local government within New York is subject to FOIA. That includes local legislative bodies like the city council. It includes local mayors, local officials like that. It includes the governor's office. It does not include the state legislature in Albany. The legislature, in its wisdom, has exempted itself from FOIA. And it does not include the court system. Courts are subject to a completely different disclosure regime. And we're not going to talk about that today. So that is, hang on a second. That's who's covered. Now, what is a record? What is it that you can get under FOIA? A record means any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form whatsoever. So it includes emails, documents, texts, electronic files, databases, charts, graphics, reports, basically anything that's in written form. It doesn't include physical objects. So you can't foil a file cabinet containing documents. You can't foil a scale model of some building that's going to be built. But any record is theoretically subject to FOIA as long as it's held by an agency. It only applies to existing records, so an agency doesn't have to create a new record in response to a request. If you do a request and say, please give me a list of the names of everybody who did X, Y, and Z, and there is no such list, the agency doesn't have to go through its records to create a list. It can just say, we don't have anything responsive. So it only applies to existing records. It also does not require the agency to answer any questions. So you can't ask for information. You can't ask them to explain something under FOIA. It just has to be, please produce the following records. And the general presumption is that any record that's subject to FOIA must be disclosed unless one of the 9 statutory exemptions applies. And those exemptions are listed here. I'm going to go through them. Some of them, if you've dealt with FOIA requests, some of them you'll see a lot and some of them hardly ever come up. So I'll go through them quickly and I'll stop to talk a bit about the ones that are sort of the most significant ones. So the first category is any records that's specifically exempted from disclosure by another statute. doesn't have to be disclosed. So that's easy. If the state or federal government passes a law saying the following categories of documents are private and don't need to be disclosed, that's it. They're beyond the scope of FOIL. That came up in New York a number of years ago. New York has a statute that the names and addresses of gun permit applicants are public records. There was a publication by a Gannett newspaper about 10 years ago where they published the names of a lot of gun permit holders. There was a big outcry, and New York passed a law called the SAFE Act that said, in part, gun permit holders can request that they be exempted from disclosure. So that law was passed. There's now a law on the books that says that. So anybody who under the SAFE Act requests that their name be exempted from disclosure, that's no longer within the scope of FOIL. The second category of exemptions is something that would constitute an unwarranted invasion of personal privacy. The term personal privacy is a little bit vague, but basically you can imagine what kinds of things might be covered. If you're seeking some internal agency report and it talks about the health status of an employee, or if it reveals the name of a sexual assault victim, that kind of thing can be an invasion of personal privacy that might justify refusal to disclose the document. The third one is anything that would impair present or imminent contract awards or collective bargaining negotiations. You can't foil an agency's negotiating position or get their views on the contract they're trying to negotiate, or get their draft of the contract they're going to propose, because it would impair negotiations. The next category that's exempt are trade secrets or information submitted to an agency by a commercial enterprise, which if disclosed would cause substantial injury to the enterprise. So this comes up a lot. Agencies collect information from private businesses, and sometimes the businesses don't want to turn it over, but they have to by law. So the thinking is it wouldn't be fair to the businesses to make them turn over information to a government agency and then have that information be subject to disclosure via FOIL. So, but it has to be a genuine trade secret, or it has to be genuinely sensitive commercial information, and it must actually cause substantial injury if it was disclosed. The next category, and this is one that comes up a lot, is records are exempt from disclosure if they're records that are compiled for law enforcement purposes, and which, if disclosed, would do one of four things. Would interfere with an ongoing law enforcement investigation or judicial proceeding, would deprive a person of a right to fair trial, would identify a confidential source or disclose confidential information relating to a criminal investigation, or would reveal criminal investigative techniques or procedures except for routine techniques and procedures. This exemption is cited very frequently by agencies, and it's often miscited. It's overused, and it's usually worth challenging if an agency says something's exempt on this basis. First of all, it has to be something that was compiled for law enforcement purposes. So if some documents exist, they were compiled for another reason, and they happen to become the subject of an investigation, that does not make them exempt. And you get that all the time, and agencies will say, well, we can't give this to you because the Department of Justice or the Attorney General is investigating, and therefore we can't give you these documents. That's not how it works. If an agency has documents, the fact that they are subject of an investigation doesn't make them exempt. It has to be something compiled for the investigation, like a police report or an investigator's notes, or something that's created for law enforcement purposes. And even if it is a law enforcement document, it's not exempt unless it fits one of the four subcategories that follow. So it has to either interfere with a law enforcement investigation or proceeding. If the investigation or the proceeding is over, there's no way that disclosure can interfere with it anymore. So it doesn't really work for them to cite that exemption if it's a closed investigation. It can deprive a person of the right to a fair trial. That's pretty straightforward. Again, if the trial's over, that's not going to deprive anybody of their rights. Identify a confidential source or disclose confidential information. Pretty straightforward, and that one is something that will hold up usually if the NYPD or the Attorney General or someone says, this is a confidential source, this is confidential information, we can't give it to you. That's usually something that's going to be sustained if it goes to court. And the last one is if it reveals criminal investigative techniques or procedures, but not routine techniques or procedures. You get this a lot too. You'll do something, a FOIL request to a police agency, and they'll say, we can't give this to you, it would reveal investigative techniques. But what they're talking about is something that's already public. So they have to really be able to justify that sort of argument. You know, they can't say well, we can't reveal the locations of security cameras on street corners because that will interfere with criminal investigations. If everybody already knows that there's cameras on the corners, that's not a secret, and revealing it won't interfere with anything. The next exemption is anything that could endanger the life or safety of any person. That's very broad, also somewhat self-explanatory. Somebody could argue you're asking for the home address of a police officer, or you're asking for something that would put someone in danger, the identity of a confidential victim or something like that. G is another big one, interagency or intra-agency materials, which are not statistical or factual tabulations or data, instructions to staff that affect the public, final agency policy, or external audits. That is sort of the internal deliberations exemption. And this is another big one. The idea is agencies have to be free to deliberate, to discuss, to come up with drafts, to discuss ideas and reject them. And if every step of that process was subject to disclosure, people wouldn't be open and honest in their internal discussions. So if the head of an agency goes to his or her deputy and they want to have an email exchange discussing possible policy options, there's a back and forth, they settle on a final approach, the final decision, the final policy is subject to disclosure, but the intermediate deliberations are not. Now, the sort of subcategories here are important because that exemption does not apply to statistical data. So for instance, if there's a long discussion within an agency of should we do this, should we do that, and there's memos back and forth, there's emails, there's documents, and they're a mix of policy suggestions and data, the agency can withhold the deliberations, they cannot withhold the data. So, if it's sort of a draft report and the draft report includes tables and statistics, the agency would have to produce the part that constitutes facts and data. It does not apply to final instructions that affect the public. So final policies are not subject to this exemption. And it does not apply to external audits. So if an agency gets audited by the comptroller's office or something, that's not subject to this interagency withholding exemption. The next category of exemption doesn't come up much. It's examination questions or answers, which are requested prior to the final administration of an exam. So if there's a civil service exam, you can't FOIL the exam before the exam's been given. And the last is if information which, if disclosed, would jeopardize the capacity of an agency or an entity that has shared information with an agency to guarantee the security of its information technology assets. So computer codes, anything that would allow somebody to get hacked or to get into their electronic systems. So in general, those are the categories of exemptions. Anything that doesn't fall within those exemptions is subject to disclosure. All right, so with that legalese out of the way, how does FOIL actually work? What do you do? Well, you submit a request to the relevant agency. And again, this applies to any state or local government agency. Every agency should have somewhere on its website the name and address of the FOIL requests officer. So you can go find whatever agency you're interested in foiling, go to their website, get the name and address. At this point, I believe all agencies are required to accept requests by email. There may be a few stragglers that don't yet, where you have to mail it in, but under the law, they're supposed to accept email requests. So you submit your request, and I'll give you a sample request in a minute of how to structure it, but basically saying what you want. The agency then has 5 business days to respond. But this initial response really is not much in terms of substance. All they have to do in 5 business days is either produce the records, deny the request, or acknowledge that they've received the request and tell you an approximate date when they'll get back to you. And the date has to be reasonable under the circumstances, which is fairly meaningless, unfortunately. So what you'll often see is you'll get the response in 5 days saying, we've received your request. We anticipate, we have a big backlog. We anticipate getting back to you in 30 days or 60 days or 90 days. You may actually get an answer at that point, or you may get another letter or email from the agency saying, we need to extend the deadline. And that can go on for a while. There's another timing provision in the statute that says once the agency decides to grant a request, it has to then produce the records within 20 business days. And if it can't do that, it has to give you a date certain within a reasonable period when it will produce the records. Now, again, that sounds great, Unfortunately, it's really been undermined by the courts. There was a period when people thought, oh, 20 days, great. If I don't get my records in 20 days, I get to say this is a denial and I get to sue. And the courts have wound up saying, no, that 20-day provision doesn't kick in at all until the agency decides to grant the request. So it does not mean they have to do anything within 20 days. It just means if they decide to grant your request, then they have 20 business days to produce the records. So it can help in some situations, but it's not a terribly useful club to get the agencies to respond in the first place, unfortunately. So how do you craft a FOIA request? You should be as specific as possible. Identify what type of record you're looking for, give a date range if you can. If you're looking for correspondence and you can limit it to certain individuals, list those individuals, be as narrow as possible. If you ask for all records concerning something, when all you need is enough information to identify one specific topic, what you're going to get is a response from the agency that says either this is overbroad, denied, and then you'll have a big fight about whether that's a proper grounds for denial, or let's say the records you requested will take us approximately 7 years to review and decide what we have to produce. So we'll get back to you in 7 years. So you don't want to give the agency an easy excuse to say, we need a lot of time for this. You have to ask for records, as I mentioned. Don't ask for information, don't ask a question, that will be denied. Don't say, please give me the names of so-and-so, or don't say, please explain the department's policy for X. You have to ask for specific records because that's all that's covered by the statute. And the agency is not required to create a new record for you. So be sure you're asking for records that you believe actually exist, or try to frame the request in a way that seeks existing records. You should always include your contact information and how you want to receive the records. If you want to receive them by email or hard copy, you can ask to receive the records in the original electronic format if you want them that way. Sometimes that's easier, especially if it's a database or something that's searchable. You might want the electronic records, not a printout that you can't search. And it has the added benefit of avoiding copying fees because agencies can charge you 25 cents a page to make physical copies. But if it's just a question of transmitting data, there's no copying fee for that. And finally, if you have a limit on what you're willing to spend on copying fees, you should say so in your letter. You can say, I authorize you to spend up to X dollars. Please contact me if the costs will be more than that. Or you can just say, please contact me before you incur any costs. Just continuing on this theme, don't use vague and overbroad terms. They can lead to denials or delays. So here's some good and bad language. And these are drawn from actual types of FOIA requests I've seen over the years. So a good way to request information about the financing of the Second Avenue subway would be to say something like, I hereby request all budgets and reports of actual and anticipated costs for the construction of the Second Avenue subway from January 1st, 2015 through January 1st, 2018, or some similar range. A badly worded request would be all records relating to the construction of the Second Avenue subway. Particularly if all you care about is financial information, there's no reason to ask for everything else. But even if you truly want all records, it's a good idea to try to find a way to narrow that, because that is going to draw a response that says you're asking for us to review millions of emails and thousands of hard copy documents. That's going to take forever. It's unreasonable. Another example, if you're researching New York's nuisance abatement laws and you want to know how many times NYPD has tried to shut down a business based on the nuisance abatement laws, you could ask for documents sufficient to identify all instances in which NYPD sought a court order to close a business pursuant to the nuisance abatement laws from, and give a date range. That's a nice narrow request. A bad request would be all documents concerning enforcement of the nuisance abatement laws. That's terrible. That's overbroad. It's not limited in time. It's not limited by topic. Even if you added a date restriction in there, I think it's still overbroad. So a lot of this is just common sense, but you'd be surprised how many requests get filed that are just unnecessarily broad and that lead to delays or denials. If you're requesting emails in particular, it's a good idea to describe the contents or the subject of the emails. You might want to provide keywords or search terms. You don't have to, but if you have, if you only want emails that contain a specific phrase, you can say so, and that might make it easier. It's always good to give a date or a time range, and it's good to limit the request by senders or recipients if you're able to do so. There may be situations where you're just querying an agency and you really want to know, you want everything from anybody in an agency who discussed a particular topic. And if that's the case, so be it. You'll have a broad request and you'll get a slow response. But if you know for a fact you're only interested in communications to and from a specific person, say so. That narrows the universe, it narrows the scope for objection, and it improves the time of a response. So you might want to say something like, I hereby request all emails to or from John Smith or Jane Doe from, give a date range, that discuss or refer to, give a topic or give a name. That's a nice narrow request that would be hard to object to. So
Matt, I actually have a question.
Sure.
I have a question. When it comes to requesting emails, are you able to request emails from elected officials? Is there some limitation on legislators, for example, at the state?
Well, the state legislature is exempt. So no, you could not request emails from a state senator or assembly person, but you can request emails from local elected officials and even from the governor. It exempts the courts and the state legislature, but that's it. So if you were to request the mayor's emails on a certain topic, you would get a host of asserted exemptions, but they couldn't just say, no, we're not giving you any emails from the mayor.
Great, thanks for that.
Okay. All right, so here's a sample FOIA request. There's no magic language. In one sense, it doesn't matter how you phrase it. You're not required to use specific words as long as it's clear what you're asking for, but it's good to include the following. You should say, I'm making this request pursuant to the Freedom of Information Law. Here's what I request. You list your request as specifically as you can, depending on what you're looking for. Sometimes you might just be asking for a single document. Sometimes it might be a type of document or a range of things. Just phrase it as best you can. Tell them what format you want it in. You might say in their original electronic format. If for some reason you want hard copies, you should say so. And then you can address the fee issue. You can say, please don't incur any costs without telling me first. Or you can say, I authorize you to spend up to X dollars. Let me know if it's going to cost more than that. You might want to remind them that they're required to respond within 5 business days of receipt, and remind them that if they deny your request in whole or in part, you're entitled to a reason citing to specific exemptions, and also ask them if they deny the request for the name and address of the appeals officer, which I will talk about in a minute, but each agency has an appeals officer if a request is denied. And then make sure you include your address and phone number and email so that they can get in touch with you. So again, there's no magic words. This is one sample of how to frame a letter, but it can be anything as long as you make clear what it is you're asking for and give the basic information. All right, so what happens? You send off your request, you get your response in 5 days, which usually will say, we've received your request, we'll get back to you by a certain date. Depending on the agency and depending on the scope of the request, you might actually get a response in a few weeks or a month or 6 months, longer. But at some point, they will either grant the request or deny it. So if the request is denied in whole or in part, the next step is to file an administrative appeal with the appeals officer at the agency in question. Every state agency, state and local agency, has a designated FOIA appeals officer. And they should tell you that in the denial letter, but if not, you can probably find it on the website. You have 30 days from the denial to file your appeal. And by denial, that includes both a blanket denial, or if they give you something, but say we withheld something else or we've redacted something, you can appeal that as well. But whatever it is you're appealing, you have 30 days. And then importantly, everything else in the statute talks about business days. This is just days. You have 30 days to file the appeal. And if you blow that deadline, you're done, you're out of luck. Once your appeal is filed, the agency has 10 business days to rule on the appeal. And again, depending on the agency, you sometimes find that appeals officers are more reasonable than the frontline records officers. I've had experiences where you get a request denied by the records officer, and then on appeal, it's granted, or at least it's partly granted, because the records appeals officers sometimes have a better sense of the law than the frontline workers do. So you file your appeal, you get your ruling, and if that's denied, then the only thing left to do is commence a lawsuit. At that point, you can go to court. And importantly, you cannot go to court before you file the appeal. You have to exhaust your administrative remedies before you go to court. So you can appeal a denial. What if the agency just never responds? What if they either never get back to you, or if they keep extending their time, or they say, this is a big request, we're very busy, we'll get back to you in 2 years. The answer is that may be appealable. There's a concept called constructive denial. If the agency fails to comply with the time requirements in the statute, that's a constructive denial. And at least there's an argument that if they simply take too long and grant themselves extension after extension, that's a constructive denial. And the statute specifically says failing to comply with time requirements is a constructive denial that's appealable. Unfortunately, as I mentioned before, courts have held that this 20-day deadline, the 20 business days, is not enforceable in any way. So you can't go to court and say, well, I filed my request and they didn't respond within 20 business days. That only applies after the agency decides to grant a request. Now, sometimes the agency will actually do that. They'll say, we're granting your request, but we need 30 more days to produce the records. If they then blow by that deadline, now they've violated the deadline, and you can say it's a constructive denial and appeal and then sue. Also, if the agency blows the initial 5 business day deadline, they don't grant, deny, or acknowledge your request in 5 business days, that's a violation, that's appealable. Or if they give a date and you can argue that date's not reasonable under the circumstances, that can be a constructive denial. So there are ways to sue, or to appeal at least, and then sue if they take forever, but it's difficult. And, I always advise my clients, or usually anyway, if an agency gives you a time that you think is a little too long to respond, and then they write to you the day before that and say, we need another 30 days, I would not take the position at that point that it's a constructive denial. I think it probably is, but the agency appeals officer is not going to agree with you. And a court probably won't agree. It really has to be a long enough delay that there's no question about it, that you can go to the appeals officer or a judge and say, look, this is absurd. I asked for X, there's no reason on the earth it should take 7 months. And by the way, they blew their deadline. And by the way, there's no authority for them to grant themselves extension after extension. So what happens if you sue? I will say filing an initial FOIA request is something you can do by yourself without a lawyer, though, of course, it always helps to have a lawyer look at it. You can also probably do an agency appeal by yourself without a lawyer. Once you get to the lawsuit stage, you do need a lawyer. So if you're with a news entity that wants to take this on and has a lawyer or is willing to pay a lawyer, that's great. If you're on your own, you've got your own site, you're a freelancer, it's expensive. And there is a possibility of getting your fees back at the end of the day if you win. FOIL has a fee shifting provision. It used to be permissive. It used to say a court may award fees. Now it says a court shall award fees to a prevailing FOIL petitioner, which sounds great. The problem is it says the court shall award fees when the petitioner substantially prevailed and the agency had no reasonable basis for denying access. So in order to get your fees, you need the judge to say both that you're right and that the agency's position was objectively unreasonable. So what still happens sometimes is you sue, you win, and the judge says, okay, I found that the agency was wrong in this case, but I'm not going to award fees because their position was not objectively unreasonable. They had a valid reason for taking their position, even though I found it wasn't enough. So you can't count on a fee award, which is unfortunate. And there's been some pressure in Albany to tighten the fee language even more to make it really mandatory, because right now it's not, but that has not happened yet. So, before suing, you really need to have a discussion with your organization, your editors. If you're a solo person, just think it through. What's this going to cost? And is it worth it given the possibility that you won't recover your fees at the end of the day? There is a very good resource called the Committee on Open Government. It's a state agency that was set up under the FOIL statute to sort of promulgate regulations about FOIL, to advise agencies to monitor FOIL cases. They have a website. It's the Committee on Open Government. I've listed the URL at the bottom of this slide. They issue advisory opinions. So that works 2 ways. You can either write to them and say, hey, I foiled X, Y, Z. The agency said no for the following reasons. What do you think? And they'll write you back a letter saying, we, the Committee on Open Government, have looked at this and we believe the agency is wrong, or maybe the agency is right. And you can then take that back to the agency or take it to the appeals officer. And it's not binding, but it's persuasive. Courts also treated them as not binding, but helpful. The website that I listed, the Open Government website, also has a database. It has actually 2 databases, a database of court decisions on FOIL issues that you can search, and it's indexed by topic. So you can look at privacy or life and safety, or by category and find cases resolving a particular issue. It also has a database of their own advisory opinions, so that can be helpful as well.
Matt,
yeah.
Oh, a question just came in.
Sure.
From Ted Phillips.
Okay.
He's asking, a frequent reason given for denials of government emails are that they are inter-agency or intra-agency materials. What can reporters do when they get denials of this kind?
Okay, well, that goes back to something I touched on before with this whole concept of what is an interagency document. It is true that if it's an interagency document that's really sort of deliberative and non-final, they can justify withholding it because of that exemption. But that exemption does not apply to factual or statistical data. So an internal email that sort of gives information is factual, that's not subject to that exemption. And if it's a mix of information and policy or advice or discussion, they have to at least produce a redacted version. And there's case law saying, if it's possible to redact something, you should redact. It also does not apply to final decisions. So if it's an email from the mayor or from a head of an agency to a subordinate saying, I've had it, from now on, we're going to do the following things, go get it done. That's an instruction that affects the public. And that is not something that can be withheld under the interagency exemption. And there are other things as well that don't fall within that exemption. So it's kind of a mixed bag. Yes, it's a real exemption. Yes, some things can and are withheld on that basis, but not everything. And it's overused. Agencies often try to use that to withhold everything when at most they should be withholding certain things. So it's always, if you get a denial like that, it's worth appealing. And it's particularly worth appealing if you know for a fact that there's some factual data in there, for instance. I've had situations where this isn't specifically about emails, but where, for instance, the MTA has a report that they put out as an internal draft, and they want to withhold it on that grounds because it's non-final, it's internal, it was just for discussion purposes. If the reporter knows that there happens to be a section in there that gives statistics on subway accidents or subway delays, you can go right back and say, okay, I don't think any of this should be withheld, but at the very least, give us the factual data. There's no grounds for withholding this table or this subject matter. So that's certainly something you can do. Does that answer the question? Yeah, I can't actually see anybody, so I don't know.
Ted, if you want to unmute and talk, that's fine. Nope, I guess he's satisfied.
Okay. Good. Okay. The other thing I'll say that comes up with that exemption is there's often a question about how that applies to external private companies that get retained to do government work. And the short answer is it can apply. So if a government agency hires, a business consultant or an auditor, well, not an auditor, a business consultant or some outside entity that's a private company to do something that's really a governmental function to advise them, and there's back and forth communications between this private company and the government agency, you might get a denial of a FOIA request under the interagency exemption. And if you say, well, wait a minute, it's not interagency, this is not a government agency, the response will be, yes, but they were retained by us to do work for us. They are effectively a government agency for these purposes. And the courts will sometimes say, yes, that's correct. Okay. I'm going to move on to FOIA, unless anybody has more questions about the state FOIA law. And I'll have time for questions at the end, so don't feel compelled to jump in now. All right, let me say a few words about the Federal Freedom of Information Act. It's a very similar statute. It was passed in 1966 to provide for public access to federal government records, just like FOIA provides access to state and local government records. FOIA is a little bit more limited in terms of which kinds of entities it applies to. It applies only to executive agencies of the federal government. So it applies to the FBI, the Department of Justice, the Defense Department, Health and Human Services, et cetera. It does not apply to Congress. It does not apply to the courts, and it does not apply to the president or to the president's immediate staff. So It really only is executive agencies that are subject to FOIA. So like FOIA applies to records, agency-generated records in the agency's possession. The agency is not required to go out and get documents from another source in response to a FOIA request. It applies to written documents, electronic records, tapes, photos, etc. Just like FOIA, does not apply to physical objects. You can't subpoena a gun or a document from a physical object from the Smithsonian. And any person can request records for any purpose. You don't have to say why. You don't even have to say, other than your name, you don't have to say who you are. You don't have to say I'm a journalist. You don't have to say why you want them. The caveat is that, as I will talk about later, it can be good in terms of getting a fee waiver to say that you're a journalist and explain why you want them, but I'll come back to that. The statute applies to existing records only. It does not require an agency to create a new record, and it also doesn't require them to answer questions or give you information. It's only records. And the time periods are a little bit different. The agency has 20 days to grant or deny a request. They can give themselves a short extension unless there's exceptional circumstances. Again, it sounds good. In reality, that's not usually what happens. They will always have some sort of unusual circumstance why they think they need longer, but that's at least the initial standard. All right, so again, as with FOIA, a document that's subject to FOIA is presumably subject to disclosure, presumptively subject to disclosure unless an exemption applies. And the exemptions under FOIA, some of them are similar to FOIA and some are different because you're talking about different issues at the federal level. The big difference is that on the federal level, the first exemption is for national security and foreign policy secrets. Those are exempt from FOIA. The caveat is the government doesn't just get to say anything at random is a national security secret. It has to be a record that's authorized by an executive order of the president to be kept secret, and it must be something that was duly classified under that order. So the president has to say the following types of documents are national security or foreign policy secrets, and they have to be classified. So that's the first exemption. The second exemption under FOIA is for internal agency policy rules and practices. That doesn't come up much. It's really just sort of mundane day-to-day things that are exempt. So if you want the Department of Justice's sick leave policies, or if you want a map of assigned parking spaces for Department of Labor employees, that's exempt. Internal agency rules and practices. There's also a catch-all, just as there is in FOIA, for information exempted by other statutes. So for example, the Census Act provides that census data is confidential, so that's not subject to FOIA. Trade secrets and commercial information obtained from businesses in confidence is exempt. Internal agency memos and policy discussions, that's similar to the interagency exemption under FOIA. That includes attorney-client privilege documents, working papers, drafts, preliminary opinions, anything used in the advisory or deliberative process. Personal information such as medical reports that would invade privacy if disclosed are exempt from FOIA. Law enforcement investigative information is exempt. And this is similar to what we talked about under FOIA. This only applies if the information was compiled for law enforcement purposes, and it only applies to the extent that production could reasonably be expected to interfere with enforcement proceedings, deprive a person of a fair trial, constitute an unwarranted invasion of privacy, disclose the identity of a confidential source, disclose techniques and procedures of law enforcement, or endanger the life or safety of any individual. So all the same considerations we talked about with FOIA for that exemption apply here. There's also an exemption for federally regulated financial institutions, meaning banks. Covers reports prepared by federal agencies about the condition of banks and other institutions. So if somebody does a stress test on Chase Bank or Citibank, and there's a report somewhere in Washington that says this bank has the following financial situation, that's not disclosable. And the last one is probably something that none of you will ever deal with, and that's oil and gas well data of private companies. And it's a very narrow exemption designed to prevent speculators from obtaining information about the location of oil and gas wells of private companies. It rarely comes up, and my guess would be that was stuck in there by oil and gas interests who really were worried about the prospect of disclosure. So that's not something you have to worry about much. So those are the FOIA exemptions. So how do you craft a FOIA request? Each agency has its own rules for what has to be included in the request. So you need to check the website of the particular agency you're interested in. You may be able to submit your request online through an agency portal, depending on the agency. The request has to reasonably describe the record sought. As with FOIA, it should be as narrow and specific as possible. And as with FOIA, an agency is not required to create a new record, answer questions, or provide information that's not contained in a record. There's also a good FOIA letter generator on the Reporters Committee for Freedom of the Press website, and I gave the URL there. It's www.ifoia.org. That will help you craft a letter and sort of walk you through how to submit it and track the response. Okay. Fees. So under the state FOIA law, you can be charged copying fees, but not research fees. At the federal level, they can charge you search fees as well, search and copying fees. You can get a fee waiver if you can show that you're seeking the records and that they're of great significance to public understanding of government activities. They don't like to grant, agencies don't like to grant waivers. It's probably going to be a no, but if you think this is something of critical public importance and you can make your case, it can't hurt to throw that into your letter. Say you request a fee waiver because this information is vital to public understanding of XYZ for the following reasons, see what they say. If a waiver is not granted, you'll be put in a fee category depending on the nature of the requester. Generally speaking, journalists have more, don't pay as much in fees as commercial users. So it's always good to say, you know, if my fee waiver is not granted, please note that I'm a journalist and I intend to disseminate this to the public. Please, you know, calculate my fees accordingly. What happens if your request is denied? Again, if the request is denied, the next step is an administrative appeal. Each agency has different deadlines, so you have to check the agency website to see when your appeal is due. And as with FOIA, if your appeal is denied, your next step is to sue. There's also this concept of constructive denial at the federal FOIA level. If the agency simply denies the request, that's a constructive denial. And if that happens, you can sue without going through the agency appeal process. And again, as with FOIA, a prevailing plaintiff may be awarded attorney's fees, but it's not mandatory and it's certainly not guaranteed. So that's it for my basic presentation. I'm happy to answer any questions anybody has about sort of general questions or specifics. Colin, do you want to look at the chat or should I take a look at that? I see there is a chat, but I don't have it open.
Yeah. So yeah, you can all join the, Matt, you can probably stop sharing your screen now. And then
Okay.
One question that I had actually, so when it comes to using FOIA, FOIL or FOIA, where does Port Authority fall? Would that fall under New Jersey's Oprah law, or would that be New York State? Because it's kind of it's a joint endeavor.
That's an interesting question. I actually don't know the answer. I've never tried to get documents from the Port Authority. You're right, it's a joint agency. It's not really within either state.
So I think when Bridgegate happened,
Yeah.
right, with Chris Christie, that might have initially been an Oprah request. Oprah is the New Jersey law, but I'm actually not 100% sure. I don't know if anyone on the call has experience with Port Authority filings, but that's one of those agencies that straddles two different states.
Yeah, but it would not be FOIA. It wouldn't be the federal statute, but I'm not sure which state statute it would be.
It would be, yeah. It might be Oprah in New Jersey. I'm not a New Jersey reporter, so.
Yeah.
Does anyone else have any questions for Matt, or wants any quandaries that you've had, any challenges that you want to share? Ted is asking, you mentioned case law for providing redacted documents under FOIL as opposed to a blanket denial.
Yeah.
Do you know what case that is? I've often asked for redacted versions, but as a fight in citing case law would be helpful.
Yeah, I don't have the site off the top of my head. I can pull it out. It's not quite as simple as I indicated. There are cases saying that if an agency cites specific types of exemptions, they have to provide redacted documents. There are other cases saying that that's limited and it doesn't apply to every kind of exemption. I have to dig the case law out, but I'd be happy to, maybe I can circulate that to Colin, or Ted, if you want to email me directly, I can send you the link once I find it.
Yeah,
Oh,
Ted is a former board member of Deadline Club, so.
Okay, I see somebody just posted that Port Authority is subject to both. That both Oprah and FOIA. Okay.
That would make sense since it straddles both areas.
Yeah,
But
yeah.
I'm not even sure how you would determine ownership, who,
Yeah,
under what law.
no, I'm not sure.
I just posted Matt's email in the chat as well. Another question, when an agency gives you redacted documents, can you repeal the fact of those for those redactions? So you can appeal
Yes.
redactions within a document.
Yes, if they're redacting anything, they have to give you a reason. They have to tell you what exemption they're citing, and that is definitely appealable.
I wonder how you would indicate what you want unredacted in the request. Like say there's just like they provide you a document and it's mostly redacted.
Yeah,
I wonder how you would specify what it is that you want to be redacted in that case.
yeah, it's tricky, and that's a reason to appeal, even if you don't know, because often the appellate officer will sort of tell you more. Sometimes the initial denial will just be, we're producing the following documents, but we've redacted certain information pursuant to exemption C. But you don't know what it is they've redacted, and then you can appeal, and the appeals officer may say, they may unredact, or they may say, no, I'm maintaining the redaction because this is information concerning XYZ, and therefore it's exempt. And at least then you know what it is as a category that's been withheld.
So there's another question from David Brand. District attorney offices have a few times told me material like specific training documents or presentations about office policies was, quote, attorney work product, unquote. Do you think of that? What do you think of that response?
Yeah.
He's having trouble with his mic, and he also has a 2-year-old next
Yeah.
to him, just like Ted does.
Yeah.
Are all the 2-year-olds aspiring journalists or media lawyers, perhaps?
Yeah, well, I'm keeping my 4-year-old aspiring media lawyer out of the room right now, so I understand. My response is I don't like it, but I get it, and I think it's probably valid. It's, may fall within this idea of sort of interagency deliberative materials. I've never had any luck getting attorney-client privilege materials out there. Attorney work product is a little more ambiguous. Work product can just be, if the attorney advises the staff, here's how you should respond to FOIA requests or something. That's not exactly privilege, but it's work product, and I think judges would probably allow that to be withheld if it came down to it.
So Ted has another question. He says, a fight I've run into a few times has to do with meeting minutes. There's some ambiguity in the law. Minutes are available under open meetings law 14 days after a meeting, but according to FOIA, so it's FOIA, they can delay access to meeting minutes by a month, but under open meetings law, it's 14 days. I guess there's a lack of clarity there between the different timeframes.
Yeah, no, I've never encountered that. I know, I think under the open meetings law, aren't they supposed to post the minutes without you having to ask for it?
There is, so the Committee on Open Government does have a great deal of advisory opinions. Maybe they're, and they also have advisory opinions on open meetings law.
Yeah, they have a whole section on the open meetings law on their site as well.
Oh, Johanna Berkman is asking, what exactly is open meetings law?
So the open meetings law is a completely different statute that requires public bodies to have open meetings. Basically, it provides for access to the meetings of boards and committees and agencies as opposed to the documents. And I see Colin just posted a link.
There's some advisory opinions there. Yeah, I think one of the things that open meetings law governs, I think, is also quorum and what is what not a public meeting, right? Like when a certain number of officials are together in a room and
Right. If two
you know,
officials are emailing each other, is that a meeting? That kind of thing.
Yeah, yeah. I mean, is it possible to have an illegal meeting if it's just like a social event with a certain number, with certain threshold of officials in one room? Nope, looks like Matt froze, but certainly thanks for all these questions. They're great. If you have any others, or if you want to jump on camera and want to ask Matt anything, please do. I can also share with you all that tonight actually kicks off the Deadline Club's upcoming office hours with Matt. So every month we're going to have open office hours with Matt for 1 hour the first Monday of every month. So you're welcome to come and bring any of your questions, your legal challenges, and he will do his best to answer them, answer those questions. And it's we're grateful to have Matt provide that service, because it's of a great need, and I'm sure that there are many situations where you have questions, you're not sure what to do, but he's graciously offered his services to the Deadline Club and its members. So it is also for members. So you do have to be a Deadline Club member in order to utilize the open office hours, which will start Monday, February 7th at 5 p.m. And if you're on our list, our mailing list, you'll hear about it more. But I just wanted to announce that tonight because that's pretty exciting for us, and we're really grateful to Matt for offering his services.
I'm happy to do it, and I'm looking forward to the office hours. So feel free to chime in if anybody has questions about anything, freedom of information matters, but also other media law issues you might be facing.
Ted qualified his ambiguity a little bit in regard to meeting minutes access. Minutes, this is a quote from the law, I guess. Minutes of meetings of all public bodies shall be available to the public in accordance with the provisions of the Freedom of Information law within 2 weeks from the date of such meeting, except that minutes taken pursuant to subdivision 2 of this section shall be available to the public within 1 week from the date of executive session.
That's interesting. I've never focused on that.
Well, Ted, do you want to come back to our office hours on the 7th? And maybe if you have a specific example that it's situation that you face, you can bring that to us.
Yeah, I'd be curious how that plays out in practice. What sort of response you get? Yeah,
Ted's saying that local governments interpret it as him having to FOIL for a request for the minute. Okay. Well, I mean, we have time until 7:30, but if no one has anything, pressing they want to ask Matt, we can all go have dinner. Okay. Anything else, Matt? Do you want to share in closing?
No, I would just say that FOIL and FOIA are both really good tools. They can be incredibly frustrating, and there's delays, there's denials, there's all sorts of frustrations, but it's also a really good way to get information out of the government. And, people have come up with great stories based on information they've gotten through Freedom of Information requests. So bear that in mind.
Yeah, absolutely. Okay. Well, thanks again for everyone being here tonight, and keep eyes on our announcements about the office hours coming up. And just it's about a week and a half or so, or 2. Yeah. So, okay. Very good.
Great.
Thank you all.
Bye, everybody.